get started and see what our agenda looks like. So we're going to have an introduction. I want to kind of introduce you to some policy, legislative policies and things like that that drive the guardianship and incapacity statutes, and kind of remind everyone that guardianship is a two-pronged process. Before a guardian or other alternative is put in place by a court, there has to be a determination of incapacity. So we're going to kind of go start with that as our introduction. And then we're going to look a little closer at when you petition to determine incapacity. What does the petition have to include, and some issues related to that. I want to take a little focused look at committee examinations and the reports that come out of those. If anybody practices in this area, you're going to be familiar with what these examinations forms look like, in all likelihood, and some of the issues that can arise. We're going to look at, in our fourth section, determining incapacity and the transfer of rights from an incapacitated person to a guardian, and how that process goes, and some of the legal issues that come up. We're going to, hopefully time gives us, we're going to have time to look at examples of local cases of restored capacity. One case in particular that's been in the headlines in the Orlando area. And then, as always, we'll conclude with some questions, or opportunity to ask questions, and we'll answer those. So with that, let's get started. We have a lot to cover in our short hour today. So as any of you who practice or have been involved in guardianships, Chapter 744, as you know, is the Florida statutes chapter that governs guardianships. A prerequisite to ordering a permanent guardianship is a determination of at least partial incapacity. So when people speak of guardianship, what you're speaking of a two-pronged process. And if there's a guardian involved in any kind of permanent capacity, then there must have already been a determination of incapacity, at least to a certain extent. The definition of an incapacitated person per the statute means a person who has been judicially determined to lack the capacity to manage at least some of their property, or to meet at least some of the essential health and safety requirements of the person. So we're looking at people who cannot manage their property or cannot manage their own personal care and safety. Manage property means to take those actions necessary to obtain, administer, and dispose of property and income therefrom. Meet essential requirements for your health and safety means to take those actions necessary to provide for the health care, food, shelter, clothing, personal hygiene, or other care, without which serious and imminent physical injury or illness is more likely than not to occur. Those definitions are found in section 744.102 subsection 12 of the Florida statutes. Just as a note, as we go through today, as a lot of people are familiar with, in 2020 we had a change to the changes to Chapter 744. To the extent there's some substantial changes in relation to the sections we go through today, I'll try to remember and note that. There's not a lot of them really. Most of the changes made in the incapacity related statutes were more to clean up language, take out superfluous language, that sort of thing. But if there's anything substantive, I'll note it as we go through. That is a recent change. But so let's look at 744.1012 Florida statutes now. This is where you find the overriding policies and legislative intent that the legislature expressed in that chapter, and as it relates to incapacity, and what their goals here, and what the primary policy should be in play when trying to effectuate the statute and the incapacity procedures set forth therein. There's three main ones that relate to incapacity. The first one is deprivation of civil and legal rights should only be had to the extent it is necessary. It is desirable to make available the least restrictive means possible when a person is only partially incapacitated. That's number two. Number three, incapacitated persons should participate as much as possible in all decisions affecting them. Now, I'm going to tell you, as someone who practices in this area, I think that third goal and legislative policy is overridden or overlooked sometimes. There's something about when people are declared incapacitated, even just partially, there's this thought process that they should not be participating in decisions that affect them, even if they, because they're in the category of rights that have been taken away from them. And I think people forget about this, that there still may be a limited extent. They may not be able to totally make those decisions in such a way that would permit them to do so in a safe way. But to the extent there's possible, it's possible at least maybe to give them a choice between maybe some decisions to be made in response to their care, their property. I think this directive from the legislature requires us as people who participate in these processes to see that that's done. So let's move on to our second item on our agenda. Let's look at how you petition to determine incapacity. Here we're going to be looking at 744.3201 Florida statute. And it says, any adult person can petition to determine incapacity by submitting a verified petition, verified meaning sworn, that contains the statutory requirements of section 744.3201 Florida statutes. And those are, you state the name, age, and present address of the petitioner and his or her relationship to the alleged incapacitated person. State the name, age, county of residence, and present address of the alleged incapacitated person. Specify the primary language spoken by the alleged incapacitated person, if known. That's important later on, as you'll see, because the examining committee is required to communicate with the alleged incapacitated person in their primary language, either directly or through an interpreter, to make sure that it's not miscommunication or lack of understanding of the language that is causing signs of incapacity in the examination. In the petition, subsection D, you must allege that the petitioner believes the alleged incapacitated person to be incapacitated and specify the factual information on which such belief is based, and the names and addresses of all persons known to the petitioner who have knowledge of such facts through personal observations. I have seen the allegations in some of these petitions be very sparse. Just saying things like my mom has memory issues, I don't think probably meets this criteria. I think you have to give some kind of factual basis, that's things that you've observed that would lead you to the belief that they may be incapacitated. And again, that should be done through personal observation, not because someone called and told you that they forgot to pay a bill or something like that. Just saying that you heard that they're having memory problems, you heard they didn't pay a bill, I'm not so sure that meets this, because it says you have to have specified factual information and on which you base your belief. And so when I do these, I personally try to get as many specific examples of which they've observed or in which other people have observed, and give their names and information, their addresses and such, and provide as much specificity as possible. I think it can obviously helps you comply with the requirements under the statute, but it also helps, I think, the examining committee we'll look at later, who's going to be charged with going out and examining these folks that are AIPs, alleged incapacitated persons. It helps them to understand what the concerns are and what they should be looking for. On our petition, we also need to state the name and address of the alleged incapacitated person's attendant or family physician, if known. This is, I think, extremely important because, again, it helps the examining committee figure out what issues may be in play. It helps them get good background information and can keep there being an issue of misidentifying some kind of problem, which maybe is explained because of there's lack of hearing or lack of comprehension that has nothing to do with intellectual capacity. Subsection F, state which rights that are enumerated in another section of the statute, 744.3215, that the alleged incapacitated incapacitated person is incapable of exercising to the best of petitioner's knowledge. If the petitioner has insufficient experience to make such judgment, the petition must state so. We're going to look at an example of a petition here in a moment, and you'll see there's a list of them, and it just copies the list in 744.3215. You know, do they have the ability, you know, to choose where they live, things of that sort. G, state the names, relationships, and addresses of the next of kin of the alleged incapacitated person, so far as known, specifying the dates of birth of any whom are minors. Obviously, the purpose of this is to make sure people who, the next of kin are the people who would have an interest in the proceedings. And quite frankly, sometimes they're the only people that are going to have any kind of adversarial proceeding or position, or be able to bring up any kind of position that is antagonistic or an adversarial to the petitioner, especially if we're dealing with someone who's incapacitated. And they might be the only person that might be bringing issues up that the court wouldn't otherwise be aware of. So the law says that they need to be identified, and you'll see later they get notice of these proceedings. Subsection H requires a copy of any petition for appointment of guardian or emergency temporary guardian, if applicable, be filed along with a petition to determine incapacity. The reason for that is at the time of the hearing, when a judge has to make a decision to determine incapacity, they have to either appoint a guardian or ensure there's alternative means in place that can protect that person. As you can imagine, it's not really fair to declare someone incapacitated, lose the ability to exercise any legal rights, but not have a guardian or some other means in place as soon as that happens, so that someone can look out for that person who can no longer exercise those rights. So I want to give you an example of what a petition to determine incapacity looks like. This is pretty basic. You see this pretty form driven. You see it in almost any petition to determine incapacity follows this sort of form. It lists out all those things we just went through in the statute. As you see there in paragraph 4, those are the check off, the specific rights. Can they personally apply for government benefits? Can they contract? Can they sue and defend lawsuits? Can they travel? Those sort of things as you see there. This sort of form, or any that you can find with your local courts, so if they have forms available, or with the Florida Bar, they all pretty much follow this guideline. More issues related to the petition. Venue, where do you file? The venue, according to section 744.1097, subsection 1 of Florida statutes, is where the alleged incapacitated person is found or resides. This can be a little tricky sometimes. Sometimes people become incapacitated because they've been in a car accident or some kind of medical emergency, or situation that has arisen. They had a stroke, and at the time, whatever that happens, they may physically be located in one county. Maybe they live in Seminole County, but they were visiting Disney at the time they had the stroke, and they were taken to the nearest hospital that may be in Osceola County. And you've got two completely different circuits involved. But technically, it can be either where they're found at that time or where they reside. And sometimes you have to think about if they're at the moment you file the petition, they're in a facility, but they're going to be released in a few days and go to their home. It may make sense to have the venue where they typically reside, where they're the county in which they're residents. The court process, there's one for appointment of counsel and examining committees. The details are set up in section 744.331. Most circuits have a list of counsel who have either volunteered or through other means have agreed to act as counsel for alleged incapacitated persons. And there's also people on the examining committee. And if you go through there, that's one of the sections where we've had a little bit of a substantive change. I direct your attention to 744.331, the examining committee. It's a 3-person membership, one of which must be a psychiatrist or a physician. And then there's a list of other people that may serve in the other two spots on that committee. One of the more substantive changes, and I thought it was a little, at least worth pointing out is prior, a nurse practitioner was listed as one of the folks that could serve on an examining committee. That's been taken out and it's been replaced with an advanced practice registered nurse. I'm not sure the substantive difference. Obviously, there's some between a registered nurse and of advanced practice capabilities and a nurse practitioner, but just note that that's probably changed the list some since that changed in 2020. So so there's that process, and when the petition is filed, those things, the court or the clerk has a list, and those are they're chosen randomly, from what I understand in most cases, and they should get notice of their appointments. So what are the notice requirements? As you can imagine, when someone has made an allegation of incapacity, that's a pretty serious allegation in our law. Under the law, we certainly take that seriously, and we don't want to leave that hanging out there. So the statutes have and statutory scheme that's been put in place is meant to move things along, give proper notice to not only the alleged incapacitated person, but the other interested parties, such as the next of kin, and to move the process along as quickly as possible. As we talked about just now, when if you're gonna have an appointment of counsel to represent the alleged incapacitated person, and you're gonna have 3 people appointed to examine them, you want to make sure that the proper notices, proper copies goes out to these folks, and that they have certain time limits to comply with their obligations. So let's look a little bit more closely at that. Section 744.331 provides the notice on the alleged incapacitated person, probably the most important notice of all. Service is accomplished by court-appointed counsel, and it must contain copies of the petitions and state the time and place of the incapacity hearing, and advise an attorney has been appointed for representation, and warn if it is determined at such hearing that this individual, the AIP, is at least in part incapacitated to exercise certain rights, a guardian may then be appointed to exercise those rights instead of them. You know, if you're involved in any other kind of civil matter, you know, service is accomplished usually through personal service, through a process server. And probate related matters, it's usually done by formal notice, certified mail, that sort of thing. So this is a little different. In this case, it's actually it's performed on the AIP by the court-appointed counsel, taking notice along with copies of the petition and a notice that states the time and place of the incapacity hearing, and has these advises specifically about that they may lose their rights at that hearing. That all has to be served on the alleged incapacitated person by their court-appointed counsel. Why do they do that? If you're not familiar, primarily the driving force is because these are folks that may have some, you know, they've been alleged to be incapacitated. They may be elderly, they may be disabled, they may be suffering from other infirmities, and just having a process server show up at their door and hand them something, they may not have the capabilities to fully understand that or comprehend that. So the court presumes that it may be easier for them to understand or give them a better chance of understanding if someone who's been appointed to look out for their interests actually sits down with them, physically hands them these things and goes over the notice and the petitions with them. You also have to give the notice of next of kin, like we discussed. The notice of the hearing and the petition will go out to the next of kin as listed in the petition to determine incapacity. I have had situations where people say, I don't know who the next of kin is, and the court, in my experience, will order you to take some diligent steps to find out who they are. You know, ask the alleged incapacitated person if they're unable to respond, do some kind of check. There's things that people can do to find out relatives and things of that sort. I'd also remind you to check your local procedures. Judges have put certain things in place. Not only do they have these rotating lists from which they usually draw to select their court-appointed counsel and examining committee, but they sometimes have in place about selecting dates for hearings and things of that sort. So it's always a good idea to go back and check your local circuit for administration orders, and the judge that handles them. Sometimes they have their own peculiar orders that they like to follow. Just for example, if you've ever done anything in the 18th Judicial Circuit close to us here in Orlando, which is Brevard and Seminole counties, they have a checklist, and I've put a copy of that on here. Hopefully it's not completely blurry, and you can see that, but if not, you can get it from their website. If you submit with this checklist, it moves things along a lot more easier. So let's look at what the process is that the committees have to go under and the other parties that are playing a part in this. Let's look a little bit more specifically what that section 744.331, subsection 3 in this case, tells them that they have to do. Within 5 days after the petition for determination of incapacity has been filed, the court shall appoint an examining committee consisting of 3 members. 1 member must be a psychiatrist or other physician. The remaining members must be either a psychologist, a gerontologist, another psychiatrist or other physician, a registered nurse, nurse practitioner, licensed social worker, a person with an advanced degree, and gerontology from an accredited institution of higher education, or other person who, by knowledge, skill, experience, training, etc., may, in the court's discretion, advise the court in the form of an expert opinion. This is the section I wanted to update you or remind you again that we had a change in the rules recently, and now nurse practitioner has been replaced with the registered nurse with an advanced accreditation there. And note, one of the 3 members of the committee must have knowledge of the type of incapacity alleged in the petition. Other than the physician, that's usually, or the psychiatrist that's chosen, I don't know how much goes into choosing the other 2 folks and to determine if they have knowledge of the type of incapacity alleged in the petition. In my personal experience and from a practical standpoint, I think the people that serve on these committees, obviously they don't get paid a lot, and a lot of times do not get paid if there's ultimately no incapacity finding, or there's insufficient assets. Oftentimes they don't get paid at all. I admire the people that are willing to do that. In my experience, you see a lot of social workers and sometimes nurses, but it's definitely hard to just get a complete variety of people and say, hey, I want everyone to be an expert on this specific type of incapacity. That's going to be a little difficult, but usually with your physician or your psychiatrist, they probably have knowledge of any type of incapacity just by virtue of having their medical degree. Moving on in that subsection, unless good cause is shown, the attending or family physician may not be appointed to the committee. The only case where I've seen that could even happen is usually if it's just a small community where there's the only doctor or physician available to be appointed is also just happens to be the family physician. If the attendant or family physician is available for consultation, the committee must consult with the physician. I think that that's important to note. That's a must. That's not suggesting. They must consult with a physician. Again, that's why it's important to put it in your initial petition, put that contact information if you have knowledge of who that physician is. Members of the examining committee may not be related to or associated with one another, with the petitioner, with counsel for the petitioner, or the proposed guardian, or with the person alleged to be totally or partially incapacitated. Well, that makes sense. You don't want people examining that may, at least on paper, seem to have a conflict of interest, or have some kind of prior knowledge or personal knowledge that just is outside the context of this appointment. A member may not be employed by any private or governmental agency that has custody of or furnishes services or subsidies directly or indirectly to the person or the family of the person alleged to be incapacitated, or for whom a guardianship is sought. Again, just trying to get rid of any potential conflicts of interest. A petitioner may not serve as a member of the examining committee. I think, again, that would be obvious one. You wouldn't want that. Members of the examining committee must be able to communicate either directly or through an interpreter in the language that the alleged incapacitated person speaks, or to communicate in a medium understandable to the alleged incapacitated person if she or he is unable to communicate. The clerk of the court shall send notice of the appointment to each person appointed no later than 3 days after the court's appointment. So just backing up again, I mentioned that earlier about why you need to mention what language they speak in, use to speak, or if they have some limited communication, such as hearing or things of that, hearing issues or things like that. You need to list that so that the members can be aware of that, and that they can make sure that they comply with their statutory duty to communicate in the medium and through the language that the AIP actually understands. As you can imagine, if the AIP can't understand them, they may appear to be incapacitated simply because there's no real communication going on. So it's important to make sure that the communication is as available to the AIP as possible. And then that last sentence there, the clerk of court shall send notice of the appointment to each person appointed no later than 3 days after the court's appointment. Kind of to keep a mental timeline if you haven't been doing so, just to see how quickly these are supposed to move along. Within 5 days, you file the petition, you should have the court supposed to make the appointments. Within 3 days, the clerk is supposed to send out notice of those appointments. So now we're 8 days in theory, or no more than 8 days in since the filing of the petition for incapacity, to kind of give you an idea of the timeline, again, the timeline that these are supposed to move along. A person who has been appointed to serve as a member of an examining committee to examine an AIP may not thereafter be appointed as a guardian for that same person. Again, that's just to make sure that the person that was on the examining committee didn't have any interest in finding an incapacity, because they may later get to serve as the guardian. Each person appointed to an examining committee must file an affidavit with the court stating that he or she has completed the required courses. And you see there, and it requires the chief judge of the circuit to prepare a list of persons qualified to be members of the examining committee because they've done that. A member of an examining committee must complete a minimum of 4 hours of initial training, and the person must complete 2 hours of continuing education during each 2-year period after the initial training. So that's a pretty rigorous training regimen. For someone who just presumably doesn't do this full time. And you'll see the court may waive the initial training requirement for a person who has served for not less than 5 years on examining committees. So it seems to say, you know, once you've gotten a lot of experience on the examining committee, you don't have to keep up with that training at least every 2-year period if the judge so allows. If a person wishes to obtain his or her continuing education on the internet or by watching a video course, the person must first obtain the approval of the chief judge. So that seems to indicate to me that there's some interest in making sure the examining committees are getting this continuing education in person, probably being brought up to date on some issues to look at or be aware of when they're examining AIPs. And again, I think that just emphasizes the policies here. Wanting to make sure that the examining committee is put in the best position possible to make a valid determination on incapacity. Subsection E here, each member of the examining committee shall examine the person. Each examining committee member must determine the alleged incapacitated person's ability to exercise those rights specified in section 744.3215. We looked at those briefly in that petition determining incapacity. The things like, can they marry, can they contract, can they sue and defend, those kind of things. In addition to the examination, each examining committee member must have access to and may consider previous examinations of the person, including but not limited to habilitation plans, school records, and psychological reports, and those voluntarily offered for use by the alleged incapacitated person. So if you as an AIP, or if you're representing an AIP and you believe that this is, they do have capacity, you can certainly volunteer up any kind of reports. And then the examining committee must look at those, maybe previous records related to your medical records, especially if you've gone through some rehabilitation, either due to medical or physical limitations, that sort of thing. They have to, or they may consider, but don't have to do that. But you may want to certainly give those so that they at least know that in the report what they saw. Each member of the examining committee must file his or her report with the clerk of court within 15 days after appointment. So if we're going through our mental timeline, we're no more than hopefully 8 days in, you get they've received notice from the clerk of court. Let's say if the clerk sent it out on the 3rd day, let's say we're in the 9th or 10th day, maybe it takes a day or two for the notice to get to them. So they have 15 days or a little less if it's taken them a few days to actually see the notice to get the report filed. So they have to do their examination before that. So at this point, they should have filed their reports in theory 23 days after the petition to determine incapacity has been filed. Anybody who's been involved in these kind of things, that probably happens, if you're lucky, 50% of the time. But that's the timeline they're supposed to be working on. The examination of the alleged incapacitated person must include a comprehensive exam, a report of which shall be filed by each examining committee member as part of his or her written report. The comprehensive examination report should be an essential element, but not necessarily the only element used in making a capacity and guardianship decision in this case. That decision is made by the judge. The comprehensive examination must include, if indicated, a physical exam, a mental health exam, and a functional assessment. The physical part of the exam was a little tricky, especially during COVID, and still to a certain extent, as you can imagine, especially if you're dealing with elderly folks or people who have medical issues. Even today, people would be probably hesitant to come in personal contact with them any more than absolutely necessary. But according to this, you're supposed to have a physical examination. I've seen reports during the time of COVID, and I thought the examining committee members, especially the doctors and other medical professionals, did a great job of doing a physical examination via video, probably because they do that now with telehealth and things like that. But they have people stand, they have them show certain body parts and things like that. And so it's shown us that the physical in-person aspect of it maybe is not always necessary to get a good physical examination in. A mental health examination, people, especially people like the people with medical experience, even the social workers, a lot of times they have experience doing what's called a mini mental, where they ask the AIP questions or ask them to remember certain things, that sort of thing, and it gives them an idea of their mental health status. They'll ask them questions about how they're feeling and try to assess if they have depression and things like that as well. And then the functional assessment, again, that goes along with the mini mental to determine do they have, can they function? Do they have memory issues, or do they have comprehension issues, things like that, that may limit their ability to be able to exercise certain rights. If any of these three aspects of the examination is not indicated or cannot be accomplished for any reason, the written report must explain the reason for its omission. Each committee member's report must include, 1, to the extent possible, a diagnosis, prognosis, and recommended course of treatment. This gets a little harder when you get when you're using people who aren't medical professionals, that for them to make a diagnosis or prognosis in a medical sense, but they do a good job usually of just giving what I would call a layperson's explanation. Like, I see a person who's, is frail, they forget things, they can't cook for themselves, they can't remember to take their medicines, things like that. You can still explain that in non-medical terms and recommend that there be someone there to be responsible for that and do that for them. Number 2, the report must include an evaluation of the AIP's ability, pardon me, to retain her or his rights, including without limitation, the rights to marry, vote, contract, all those things that we've listed out before. I think one of the most important ones there, not to be overlooked though, is making decision affecting his or her social environment. Don't think that that's a throwaway. In my experience, the people that surround an AIP going forward, the kind of environment they are in many ways determines how well they do, how well they will continue to function or get better or have a high functioning life. So when you make the decisions on what facilities they shall be a part of, what kind of extra, activities they should be part of, who are the people who are going to be visiting, and things like that, it's an extremely, I think, important decision. And when that's taken away from someone, and they're at the mercy of someone else making that decision, I've seen how that can really affect people in a very significant way. So even though right to contract, obviously all those things are important, I think that's one that really should be given some thought, and determine if they really should have that right taken away. Number 3, the committee's written report must include the results of the comprehensive examination and the committee members' assessment of information provided by the attending or family physician, if any. Number 4, description of any matters with respect to which the person lacks the capacity to exercise rights, the extent of that capacity, and the factual basis for the determination that the person lacks the capacity. Essentially got to explain why you came to your conclusions. Number 5, the names of all persons present during the time the committee member conducted his or her examination. If a person other than the person who is the subject of the examination supplies answers posed to the alleged incapacitated person, the report must include the response and the name of the person supplying the answer. As you can imagine, it probably makes sense to ask if someone's been through a horrible car accident, they're suffering infirmities, mental infirmities or memory loss or anything during that, for just as an example. It may make perfect sense to ask the person there, well, who are the doctors they've been seeing? What are their names? Who's been, looked after them, or who made certain diagnosis. The person who went through everything, they may not even know who they were, who the doctor's names were. That would be probably absolutely appropriate. And if you saw that in the report, a judge or anyone else looking at that probably wouldn't have a problem. However, if you're asking the questions that are part of your exam to assess their functioning and the person's supplying all the answers, as you can imagine, that's a much more significant thing to report. Finally, the signature of the committee member and the date and time the member conducted his or her examination must be contained. Okay, so now we know what's got to be in the report. Let's look at this requirement. Within 3 days after receipt of each examining committee member's report, the clerk shall serve the report on the petitioner and the attorney for the AIP by electronic mail delivery or mail service. And they must file a certificate of service in the incapacity proceeding. So if you've been keeping up with our mental timeline, 28 days, we should have received all the examining committee reports. And within 3 days of that, the clerk serves this report on everyone else. So now we're up to 26 days. The petitioner and the attorney for the alleged incapacitated person must be served with all reports at least 10 days before the hearing on the petition. So if we're at 26 days that the reports have been sent out, that means we can't have a hearing for another 10 days. So now we're up to 36 days. After the initial petition has been filed before we can have a hearing on the petition, and that's if everybody has complied with these dates and deadlines. So that must be served with all reports, the alleged incapacitated person and the petitioner, at least 10 days before the hearing, unless the reports are not complete, in which case the petitioner and attorney for the AIP may waive the 10-day requirement and consent to the consideration of the report by the court at the adjudicatory hearing. If such service is not timely effectuated, the petitioner or the AIP may move for a continuance of the hearing. So if your reports come in late, and remember, these dates for the hearing have already been set ahead of time. They had to be in the initial in the initial notice that was served on the AIP. And that's why the judges usually go out, 45 days or so, 35 to 45 days. And if it looks like you can't get the report within that time, you can waive it if it's of interest you think more important to have that hearing, or you have to ask for a continuance and have that changed. And of course, then everybody has to be notified of that. So, so just be aware of that with your timing issues. They can be very tricky with these because you're dependent upon at least four other people other than the judiciary system to complete steps before next steps can be taken, including the appointed counsel to go out and actually do service, and the 3 examining committees to actually to complete their examination or reports. So let's look at what a report of an examining committee member might look like. A lot of the counties have their own form, and they're pretty much the same. There'll be a few maybe tweaks in them. What you see on the screen right now is the one for Orange County, and over time, I think even the examining committee members have their own form reports that will follow this, and maybe have their own additions or things they like to add. But these are good examples of what you can expect. And as you can imagine, a lot of it's just general information, name, date, where you went, where you examined them, the diagnosis, prognosis, all those things we just went through that have to be included in a report. Then they're going to go through and they're going to check off what rights they do or do not have a capacity to exercise. And this can be actually kind of confusing sometimes, because you will see, if you do this long enough, you're going to see some reports that would seem to have at least what you would think are inconsistent findings. For example, they'll say they don't have the right to contract, but then they'll say they might have the right to seek employment. Employment, at least to a certain extent, is a contract. You agree to a certain wage to do certain work for a certain wage. If you're saying the person really doesn't have the capacity to contract and be obligated to things, it kind of, you wonder how they can seek employment. Even how they can travel. To travel, you have to be able to make representations at the airport to other people that you've complied with certain steps, and if you have these other limitations, sometimes it makes you wonder how they can do both. But you will see things like that. So, and it's not always a yes all the way down, or a no all the way down. So those get a little trickier. They're going to have a physician's report there, where they're going to talk about their examination, the comprehensive examination they did under the statute. Then if they found incapacity or any kind of incapacity or lack of incapacity, or limitations on being able to exercise rights, they've got to go through a scope of guardianship and put what they believe they lack such a right that it should be given to scope of under the authority of a guardian or another person. And then this can be certainly an important recommendation. Is the guardianship going to be plenary or limited? If it's plenary, they're making a representation they really have no capacity left to make any of the legal decisions that are the statute anticipates being resolved in an incapacity proceeding. If it's limited, then a lot more analysis has to go into what the scope of that guardianship will be. This is another example that we pulled from 6th Judicial Circuit. Again, you see it's very similar to what we just looked at, maybe a little bit different formatting, maybe a question or two that wasn't in the other one. I noticed this one has a lot of living situation kind of questions involved that maybe the other one didn't, but a little bit more details in some of the sections, but pretty much follows the same idea. Also check your the local rules about examination committee reports and the confidentiality of those. There's legislation on the horizon about trying to make these more of the information in any guardianship more confidential. But a lot of the various circuits have already had their own rules in place, like they have here with the 3rd Judicial Circuit. This is Administrative Order 2020-01 that I pulled that shows that examining committee reports will be treated as confidential matters, as a confidential information like anything else under the confidentiality orders. And when they're filed, they have that protection and things of that sort. So I think you'll see that in a lot of the circuits. And I always, as a matter of course, if I'm involved in filing anything of record that's related to an alleged incapacitated person's health or mental status, I would file it confidential, even if maybe it doesn't fall directly under that statute right now. What are some of the evidentiary issues with committee reports? The first issue that comes up a lot is admissibility. People sometimes, just as a matter of practice, think they're automatically admissible, but that's been resolved by case law. Just like any other third-party report, expert report, they have to be, there has to be a person present to attest to the report and make it admissible through authenticating it, and to get over some of the hearsay objections you can make. And that can be a little tricky because sometimes these examining committee members aren't available. And remember, these dates have been set ahead and they're pretty close in time, usually to the time they've done the report. But just to be clear, the petitioner and the alleged incapacitated person may object to the introduction of any evidence or any part of those reports by simply just filing a written objection. And they're supposed to do that no later than 5 days before the adjudicatory hearing. Sometimes that's a little tricky because sometimes you're not getting the reports until a few days before the hearing. But the objection must state the basis upon which the challenge to admissibility is made. If the objection is timely filed and served, the court shall apply the rules of evidence in determining the report's admissibility. For a good cause shown, the court may extend the time to file and serve the written objection. So just be aware of that if you want to make an objection, or if you're on the other side, that there may be an objection made, and be prepared to have your examining committee member there to authenticate and explain the basis and foundation, and get over those types of objections or hearsay objections or whatever the objection may be. So oftentimes comes up, can you get an alternative examination if you don't like the examining committee reports? Can you get an alternative exam? The short answer is that in almost any case, the examining committee reports is the only examinations the court's going to compel the AIP to attend or present themselves for. But if the AIP wants to get alternative examinations, they certainly are allowed to. The statute provides that they're free to put on any evidence that they think, that is relevant at the hearing. And if they've gone and had an alternative exam by a different professional, and they want to argue that this, their professional is better than the examining committee, or had a better opportunity, has more credible, all those things, they certainly are allowed to. I don't know of any circumstance where you're probably going to find a judge is going to find that it's appropriate to compel the AIP to submit for examinations if the petitioner or another party wants them to submit to that. Okay, hearing requirements. No, only time a hearing is not required is if a majority of the examining committee members, i.e. 2, conclude that the alleged incapacitated person is not incapacitated in any respect. So if you get 2 people that come back and they say it's not, they have no incapacity whatsoever, according to the statute, in that case, the court shall dismiss the petition. Not may, shall. 744.331 subsection 4 Florida statutes. That's the only time that under the rules that you're allowed, that the court's allowed to make any kind of determinations or rulings on a petition for incapacity without having a hearing. And again, that's just to dismiss it. You can't waive the hearing. There's case law out there that says even a court-appointed attorney can't waive the hearing. And you can imagine why that's important. You want to make sure that there's this whole procedure that's been put in place to protect AIPs and make sure they're only being found incapacitated to the extent possible. Well, if everybody so-called waives it, a potentially incapacitated person waives it, then it's kind of undoes the whole purpose of the process to have court oversight and to go through this structured process before you take those rights away from someone. But you can certainly get it dismissed in favor of the AIP if you get 2 reports back. And I've moved, even when you just get the 2 and you haven't got the 3rd back, I've moved for the dismissal And the courts agreed that in the cases that I've done that they don't need to see the third one because they've already triggered, it's already enough to trigger the requirement to dismiss when you see the two that find no incapacity. So let's move on now to subsection 4 of our agenda today of 6. We're now on number 4, and let's move through this quickly so we can have some time for questions. But this goes through the rights that you lose or retain when you find incapacity, when the court goes through and determines incapacity. Section 744.1095 of Florida statutes. It says any hearing held under Chapter 744 in any hearing, an AIP or ward has the right to remain silent and refuse to testify, and this cannot be used as evidence of incapacity. They have the right to present evidence, witnesses, cross-exam, confront all witnesses, and request the hearing to be closed or open. That's at the AIP's discretion. In section 744.3215, they list out all the rights that are retained by a person who has been determined to be incapacitated, and this is subsection 1 of that section. And these are important. They still have a right, even if they're completely incapacitated, these are rights they still contain. They have a right for an annual review of the guardianship report and plan. They have a right to have continuing review of the need for restriction of his or her rights. They have a right to be restored to capacity at the earliest possible time when that can be determined. They have a right to be treated humanely, with dignity and respect, and to be protected against abuse, neglect, and exploitation. They have a right to have a qualified guardian. They have a right to be as independent as possible, including having his or her preference as to place and standard of living honored, either as he or she expressed or demonstrated his or her preference prior to their determination of incapacity, or as he or she currently expresses, insofar as such request is reasonable. That goes back to the beginning where I said I think people ignore that sometimes. The guardian thinks they've been charged with that, that right to choose their environment where they live, but they forget they're supposed to still consult, and to the extent that its request, the request is reasonable, go along with what the AIP wants. They have a right to be properly educated, to receive prudent financial management of their property, to receive services and rehabilitation necessary to maximize the quality of life, to be free from discrimination because of their incapacity, to have access to the courts, to have access to counsel, to receive visitors and communicate with others, to notice of all proceedings related to their capacity and guardianship, unless until the court finds the incapacitated person lacks the ability to comprehend the notice. They have a right to privacy, and those remain again whether they're declared incapacitated or not. And then subsection 2 lists out all those rights that we talked about earlier that you can lose if they're checked off. There's some of those that cannot be delegated to a guardian though. For example, the ones you would think marry, vote. If you can't marry or vote, that doesn't mean the guardian gets to go vote for you or pick who you're going to marry. That kind of sort of makes sense. The ones, subsection 3 lists out the ones which may be taken from you and then delegated to a guardian, such as the right to contract, sue and defend lawsuits, apply for government benefits, manage property, determine your residence, consent to medical and mental health treatment, to make decisions about your social environment. Those can be given to a guardian and will be if the court determines you can't do those, the AIP can't do those, and there's no alternative means in place. There's a subsection 4. We're not going to go through that because of time, but we are going to, I just have them listed here. There's some extraordinary acts that the guardian cannot perform without court permission, and as you can imagine, it's things like, be committed to a facility or institution, and they can't go to be put forward with medical experiments and things of that sort. They can't have their dissolution of their marriage, consent to termination of parental rights or sterilization, those kind of things. They kind of make sense that those would be extraordinary. Restored capacity, that's an important one, especially today's age, because this is coming up and more in the age of social media and where incapacitated persons can actually communicate with the outside world and show that they think that they've had restored capacity. Section 744.464 provides any interested person, including the ward, may file a suggestion of capacity. So we're at a point where they've been determined incapacity, but they can send, and there's no limitation on this, the ward can file a suggestion of incapacity. The suggestion only needs state that the ward is currently capable of exercising some or all of the rights which were removed. Upon filing, the court must immediately appoint a physician to examine the ward. Physician has 20 days to examine and his or her own report filed. All interested parties get notice and have 20 days to object. A hearing is necessary if there is an objection or if the report suggests full restoration of rights is not appropriate and must be advanced on the judge's calendar as a priority. Restoration requires proof by preponderance of the evidence. This is a little different. In incapacity, we didn't touch on that, but in incapacity is clear and convincing standard. Here you can get restored by just preponderance of the evidence. I'm surprised more people don't do this, especially wards that have a little bit savvy about them. And you do see some of those come out in the newspaper because they make good articles. Especially people, have access to internet and they can send in these things to the court. They figured out how to, send an email to the court or something that suggests that they have capacity, and they can require these, examinations and hearings on an expedited basis, on an advanced basis, routinely if they wanted to, and seek restoration on that means. Common issues for appeal. Fee disputes are always the big one. But after that, sufficiency of evidence is the most appealed issue related to incapacity proceedings. Trial court's ruling on mental capacity cannot be disturbed unless the evidence show it is clearly erroneous. Insufficient evidence, again, the times it's been found to be insufficient to meet the clear and convincing standard. In this time, I try to give you some factual situations. The ward's testimony revealed her to be coherent and fully aware of her circumstances, both financially and medically, and one member of the examining committee found the ward was oriented to person, place, and time, was aware of the instant legal proceedings, and recommended that none of her rights be removed. And another member recommended limited guardianship only as to the ward's right to manage or to make a gift. So there was a split among the examining committee, but the person testified at their own hearing and was very convincing that they understood what was going on. It was insufficient to find a ward incapacitated, again, by the clear and convincing evidence standard. When 2 of the 3 examining committee reports were filed 2 months or more before the incapacity hearing, a sworn affidavit from the ward's previous psychiatrist stated the ward's condition had improved, and a report from another psychiatrist indicated that an examination suggested the ward had sufficient mental capacity to make financial, medical, testamentary, and general personal decisions. Again, in this one, the lesson to be learned is if they can improve, so you don't want too much time between your exams and the hearing, or you give an opportunity for the AIP to argue that they've improved. I've got somewhere there is sufficient evidence as examples there because of time limitations. I'm going to skip these, but please feel free to go back and look at them in the cases that I cite here. And then I want to get an example of the local cases, and I'm sorry I don't have enough, but look this up. Douglas Arthur Keegan, Keegan. It's a local Orlando case, and for almost 7 years after he's been fighting to get restored capacity, and he recently did a few months ago. And it's a very colorful case, and I think it brings out the fact that in today's age, when he had got access to a laptop and was able to really bring attention to himself, and what he thought was an improved state of capacity, that he was able to get that restored. Again, I urge you to do that. I'm just briefly running through. I don't see any questions. If you have any, I urge you to please contact me. My contact information is now up on the screen. Forrester Phillips at fbl-law.com. You can call us here at Forrester Bowman. My number is area code 407-255-2055. I'm sorry we ran out of time. I was really looking forward to getting into some of these in detail. But again, if you have any questions, feel free to follow up. If you want to share an anecdote or a case you have and some information with me, I always love those things. Again, thank you. Have a good day.